Well, hello. Welcome back. This must be a record for me, 3 days in a row. Unfortunately, at least for me, today's video brings disappointing news. So, I woke up this morning for a couple minutes, and as I'm sure all of you do, I checked Pacer. And because something had been bothering me, I was thinking, the Scofield versus Guillard case was filed in sometime in mid-December, and I knew that service had been accomplished, but I didn't know when service was accomplished. But I knew we had to be coming up on a deadline pretty quickly for a responsive pleading. And for those of you who forgot, this is not the actual Idaho murders case where 4 University of Idaho students were murdered. This is a side case where the Tic Toc psychic in Texas accused the University of Idaho history department chair professor of being the murderer, or at least having coordinated the murders. So this is a defamation suit arising out of that. Um, so to my surprise, when I in my sleep deprived, well, groggy state, uh, my period of wakefulness between I pacer, and lo and behold, there's a new filing. Finally, this is the first new filing since the complaint, and it was titled "Declaration." And at first, I saw the handwritten Kevin Yates or Kievan Yates, or it looks like it's Kievin, but I'll say Kevin Yates. And I thought, wait, is this the person? Because remember, there was an alleged co-conspirator that the psychic alleged had done the killings at the professor's behest. So I was thinking, ooh, is this him making a declaration for some reason? But no, this is declaration of service. So, in the United States District Court for the District of Idaho, Scofield versus Guillard, declaration of service. Comes now, Kevin Yates hereby declares and says that I am over the age of 18 years and not a party to the action or related to any of the parties in the above entitled action. I received a true copy of the summons in a civil action, complaint, and demand for jury trial, civil cover sheet, and delivered the same upon Ashley Guillard by delivering to and leaving with A. Ashley Guillard, personal service, personally and in person, as opposed to B, which is substitute service, serving a person in the defendant's household at her address, but let's not look at that too long. And I declare under penalty of perjury, pursuant to the law of the state of Idaho, that the foregoing is true and correct. Date 12/29/22. And well, that's when he submitted this declaration, but process was perfected on the 27th of December at 2:31 p.m. So, in my sleep deprived state, I thought to myself, "Self, that sounds like a default or at least an application for default is coming." Because let's look back to Rule 12, our old friend Rule 12 of the Federal Rules of Civil Procedure. 12A, time to serve a responsive pleading. In general, unless another time is specified by this rule or a federal statute, the time for serving a responsive pleading is as follows. A defendant must serve an answer within 21 days after being served with the summons and complaint. So, once again, I thought to myself, there's 4 days left in December. Add the 17 left. That takes you to the 17th of January. Looked like the deadline. And today is the 19th day of January. So, once again, I thought to myself, we're 2 days past the deadline. So, by the time I checked again, this time more fully awake, we had a motion for clerk's entry of default, which reads, pursuant to Federal Rule of Civil Procedure 55A, Plaintiff Rebecca Scofield moves for a clerk's entry of default against defendant Ashley Guillard. And let's make that bigger. Usually I do that first, but forgot. Background. Plaintiff filed her complaint seeking affirmative relief on December 21st, 2022. On December 27th, defendant was served with the complaint, summons, and civil cover sheet in this matter. Defendant's deadline to file responsive pleadings was January 17th, 2023. Federal Rule of Civil Procedure 12, little a, 1, big A, 1. What we just read. To date, defendant has not filed responsive pleadings or otherwise appeared in this matter. Argument. The clerk should enter default because plaintiff seeks affirmative relief in her complaint. Defendant has been served, and defendant has failed to file responsive pleadings or otherwise defend the claims made against her. The clerk's entry of default is thus mandatory under Federal Rule of Civil Procedure 55A. We should go look at that once we finish reading this very short motion, which provides that when a party against whom a judgment for affirmative relief is sought, it, when a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend, and that failure is shown by affidavit or otherwise, the clerk must enter the party's default. Following the clerk's entry of default, plaintiff will seek an entry of default judgment under Federal Rule of Civil Procedure 55B. Conclusion. Plaintiff respectfully requests the clerk's entry of default against defendant pursuant to Federal Rule of Civil Procedure 55A, dated January 19th, 2023, signed by Wendy J. Olson and joined by Elijah Watkins and Corey Carone, attorneys for plaintiffs. So that was short and sweet. Let's go back to the Federal Rules of Civil Procedure. Wait for the hamsters in my internet to do their job. Rule 55, default judgment. So 55A, which was cited above. Entering a default. When a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend, and that failure is shown by affidavit or otherwise, the clerk must enter the party's default. Hey, look, that's the entirety of Rule 55A that was quoted in the motion. 55B, entering a judgment. B1 is by the clerk, which is what they're requesting here. If the plaintiff's claim is for a sum certain or a sum that can be made certain by computation, the clerk, on the plaintiff's request, with an affidavit showing the amount due, must enter judgment for that amount and costs against the defendant who has been defaulted for not appearing and who is neither a minor nor an incompetent person. Whereas B2, default by the court, in all other cases, the party must apply for the court for a default judgment. A default judgment may be entered against a minor or incompetent person only if represented by a general guardian, conservator, or other like fiduciary who has appeared. If the party against whom a default judgment is sought has appeared personally or by a representative, that party or its representative must be served with written notice of the application at least 7 days before the hearing. The court may conduct hearings or make referrals, preserving any federal statutory right to a jury trial when to enter a or effectuate judgment it needs to conduct an accounting, determine the amount of damages, establish the truth of any allegation by evidence, or investigate any matter. So, if for those of you who are familiar with the Alex Jones uh, defamation trial that happened in Florida, although, or no, no, that one was in Connecticut because Sandy Hook. I th- I can't remember if that one was in state court. I think I it would have had to be in federal court. But either way, if you remember, there was a default judgment entered, but they held the trial to determine the damages. So that's this Rule 55B to B to determine the damages. Well, in this case, and the okay, why did it open like this? I don't like this. But either way, I'm just going to, since I'm just skimming. In this case, jurisdiction and venue, they say this is a diversity of citizenship case because there is diversity and the controversy exceeds $75,000. And then we go down to the prayer for relief at the bottom, where Professor Scofield prays for judgment in her favor and against Guillard, as well as compensatory and punitive damages in an amount to be proved at trial, attorney's fees, costs, and disbursements incurred here, pre-judgment and post-judgment interest, and all other such relief as the court deems just and equitable. Well, in this case, by entering a default through the clerk instead of holding a hearing to determine damages, she's pretty much going to be limited to that $75,000 jurisdictional amount since she hasn't quantified specific damages. And she could still get attorney's fees and costs. I'm guessing $10 to $15,000 based on the amount of work that's gone into these two motions, and the experience of the attorneys. So it's not a ton, but it's still a victory. Maybe. Because I can pretty much guarantee now that there's probably a default judgment forthcoming. This is the application for default. But once Ashley Guillard realizes, oh shit, I'm actually on the hook for $75,000, $85,000, $90,000. I should have taken this seriously. Well, let's go back to Rule 55. Section C. Setting aside a default or a default judgment. The court may set aside an entry of default for a good cause, and it may set aside a final default judgment under Rule 60B. So, yeah, I have a feeling once she's served with the default judgment, she's going to say, "Oh shit," and either file this motion to set aside the default herself or actually finally go out and hire an attorney. And especially if she's pro se, if she doesn't hire an attorney, but even if she does hire an attorney, but says, "Well, I hired the attorney after." The court's going to set it aside because they want things to be decided on the merit, not by default. And it says here, "For good cause." Well, they're going to say, "As a matter of justice." Had a little hair on my tongue or yeah. So, think for those of you who have followed my coverage of the Delete Laws saga, well, his lawsuit that I haven't been covering, the Ironton lawsuit, he's had no justification for missing so many deadlines, so many orders to show cause, and yet he comes after it's dismissed twice and convinces the judge, "Well, you should let me back in." Um, n That's going to happen here. If she comes to the table and says, "Well, please give me a second chance." But she's got to at least make that effort. Otherwise, it's over, and we don't get the joy of seeing her squirm and seeing her try to explain away, try to bring tarot readings into court filings and even a trial. That would be wild. So, yeah, it's disappointing, at least for me. I I don't know if it's disappointing for Professor Scofield or not, because you know, $75,000 wipes away a lot of tears. But, think about Johnny Depp once again. He sued knowing how hard it would be, and he said, "It's not about the money, it's about clearing my name. It's about proving in open court I'm not a wife beater, I'm not an abuser." And I think for Professor Schofield, this could be a chance wasted because she might want her day in court, although she wouldn't have necessarily filed the default motion. Uh, well, I would have, but I'd not oppose if the defense came in and said with her motion to set aside, I'd say, okay, okay, sounds good because I want to get this all on the record, but I didn't want to sit on a skipped deadline and act like a wet blanket. I wanted to assert my rights one way or another. So it could be one or either one of those. It could be something else. But either way, nice short video today. Thanks for joining me. I will see you all real soon, I'm sure. Do all the YouTubey things, like, subscribe, share, bribe your friends to do the same, and I will see you for the next one. Have a good one. Bye-bye.